Good morning. Welcome to the Supreme Court of the United Kingdom. Today is the first day of the hearing of the appeal in G&G, which in very general terms concerns the relationship of the 1951 Geneva Convention relating to the status of refugees and the 1980 Hague Convention on the civil aspects of international child abduction. Reporting restrictions apply in this case. The court has ordered that no one shall publish or reveal the name or address of the child who is the subject of these proceedings, or publish or reveal any information which would be likely to lead to the identification of the child or of any member of her family in connection with these proceedings. These restrictions apply both to the professional media and to individuals. And if you're in any doubt about this, you should contact the communications team at the Supreme Court. I'm Lord Lloyd-Jones, and I'm sitting today with Lord Hamblin, Lord Leggett.
Good morning.
Lord Burrows.
Good morning.
And Lord Stevens.
Good morning.
We have a number of interveners in this case. The representation of the parties and the interveners is as follows. The appellant is represented by Henry Setright, Queen's Counsel, Michael Gratchen, Jason Popjoy, and Emmeline Blues. The respondent is represented by Edward Devereux, Queen's Counsel, Zain Malik, and William Tyzack. The first intervener, the Secretary of State for the Home Department, is represented by Alan Payne, Queen's Counsel, and John Goss. The second intervener, the International Centre for Family Law Policy and Practice, is represented by James Turner, Queen's Counsel, Mavish Chowdhury, and Paige Campbell. Third intervener, Reunite, which is making written submissions only, is represented by Richard Harrison, Queen's Counsel, Jennifer Perrins, and Mark Smith. The fourth intervener, Southall Black Sisters, making written submissions only, is represented by Alex Verdon, Queen's Counsel, Dr. S. Chelvan, and Charlotte Baker. The fifth intervener, the UN High Commissioner for Refugees, is represented by Raza Hussain, Queen's Counsel, Malcolm Birdling, and Gayatri Sarathi. The sixth intervener, making written submissions only, is the International Academy of Family Lawyers, represented by Mark Twomey, Queen's Counsel, Sarah Tyler, and Alexander Lang. Mr. Setright.
My Lords, the representations have already been mentioned, so there's no point in my duplicating that, but I should say that the appellant is the mother and the respondent is the father of an 8-year-old child who is the subject of these proceedings. My Lords have made the conventional order on publication. I'm going to refer to the child as P, to the appellant as the mother, and the respondent as the father in these circumstances. Now, my Lords, Mr. Payne has indicated to me that he would appreciate at this stage the opportunity of saying something very briefly to your Lordships, and I'm happy to give way to him for that purpose.
Yes. Very well, Mr. Payne. You're muted at the moment, Mr. Payne.
Beg your pardon, my Lord, I thought the muting was going to be undertaken on my behalf, or the unmuting. My Lords, I just wanted to say at the outset of the appeal that I would like once again to offer the court, the parties, and the interveners my unreserved apology for the position we find ourselves in as a result of the Secretary of State's very late change in stance. The Secretary would like to emphasise that her intention in intervening in these proceedings was and remains to assist the court in determining these difficult issues. However, in doing so, the Secretary of State has found herself confronted with issues which, from an asylum perspective, have always been considered relatively straightforward, at least from a practical perspective. This has arisen by reason of the Secretary of State's long-standing policy of not removing dependents and allowing applicants to include dependents on their asylum application. As such, there's never really been a need to forensically analyse the precise basis or the consequences flowing from a dependent, an applicant including a dependent on the application. The change in stance, regrettably made so late in the day, reflects the Secretary of State's final view, having considered all the information that came to light as the case was prepared and finalised. The highly complex issues have been difficult to resolve for the Secretary of State, but having reached a final decision, and despite the highly regrettable lateness of the decision, the Secretary had no option other than to inform the court and the parties. So once again, the Secretary apologises for the position that everyone finds themselves in today.
Thank you, Mr. Payne. Mr. Payne, Lord Leggett has a question for you.
Mr. Payne, of more interest to me when you come on this afternoon at least, than to know why it's taken so long to decide what the Secretary of State's position on the law is to know what the Secretary of State has done in considering the asylum application since it was made, and why it hasn't been determined already, if that remains the case.
Of course.
Thank you.
Lord Stevens.
I note, Mr. Payne, that the Court of Appeal, I think at paragraph 155V and 159, indicated that the Secretary of State was going to use her best efforts to prioritise consideration of a pending asylum application or the revocation of an asylum application. I was wondering what steps have actually been put in place to date to honour that obligation, and also what is going to take place in the future. That is how the timescale for Hague Convention proceedings, which is basically 6 weeks, including a right of appeal, can be accommodated in the asylum perspective. So I'd be interested to know what considerations have been given to it so far, and what is proposed, and what undertaking as the Secretary of State would be prepared to give to make sure that these two important conventions sit hand in hand, rather than being used as one to be used as the obstruction of another. So that's one of my questions, and I'd be grateful if that could also be addressed when you come to address us later. Secondly, the application, as I understand it, to put a child as a dependent on an asylum application, and indeed to make an application in the name of that child, is at the whim of, at the behest of, one parent alone. So what is the Secretary of State proposing to do to make sure that those decisions are not being used to obstruct and delay Hague Convention proceedings? Those are but two of the questions that I have at the moment, but I'd be very interested to know, as Lord Leggett has indicated, to know what is the outcome of this asylum application in relation to these applicants.
My Lord, yes.
Thank you very much indeed.
So, Mr. Payne, there are 3 matters there on which we would be grateful for your assistance.
My Lord, I'll do my best.
Thank you. Mr. Sepright.
Yes, may it please, my lords. I propose in opening not to outline at any length the history, factual or procedural of this appeal, partly because it's already set out in the statement of facts and issues and in our written case, but chiefly because, notwithstanding the generous time which this court has allowed for this appeal, there's a lot of substantive ground that I will need to cover. And that aspect of my case has been made somewhat more complicated by the recent and radical departure by the Secretary of State from the case which is set out in my learned friend's written case of the 18th of January, not so long ago.
Yes, Mr. Sethright.
Yes,
Sorry, I do apologise, but I forgot to mention one thing for Mr. Payne. That is that the ground of appeal is the first ground is have protection from refoulement pending the determination of that application. And I'd like to know what the Secretary of State's view is when that application has been determined. Because if it is whenever the appeal process has been gone through and all the judicial reviews have been gone through, well, you may say goodbye to the Hague Convention. And so I'd like the Secretary of State's views about that. Also, one potential method for making sure that there is proper liaison between these two important functions is to potentially join the Secretary of State into the Hague Convention proceedings right at the very start. And I would like to have Mr. Payne's views about that as well.
I'm grateful, my Lord. That, my Lords, we will have to deal with those aspects, and to make it quite clear to the court, in the written case of the 18th of January, submissions of law as well as submissions relating to policy were made. It appears to us, and I'm not going to go into that at this stage, it appears to us that the Secretary of State has had quite a radical change of view. For the avoidance of any doubt, we hold to and adopt what appears in these respects in the Secretary of State's document of the 18th of January. And in these submissions, I will deal with the reasons why we support that approach. But of course, I will wait to hear what Mr. Payne says in providing some fuller detail about what was going on, and we'll address that in due course in our reply. But there's a substantive change in position which we need to address. My Lords, this is an appeal against the decision of the Court of Appeal, which has been reported as G&G. By its decision, the Court of Appeal lifted a stay that had been placed on an application that has been made by the father for a summary return to South Africa under the Hague Convention of 1980 of the party's child P. That stay was imposed by Mrs. Justice Leven by an order made on the 5th of June 2020, and that's EF page 3201 to 3, with her judgment at 304 to 311. She made that order on the understanding, a mistaken understanding, because of what turned out to be a miscommunication by the Home Office, that P had made her own independent freestanding claim for asylum. In fact, it became apparent at the beginning of the appeal before the Court of Appeal that she had not, but that, as we will say is the common practice, had been named as a dependent on a claim for asylum made by the mother. That's dealt with in the judgment of the Court of Appeal at EG 256, paragraph 17. And on the appellant's case, that factual discrepancy between the position as it appeared to be before Mrs. Justice Leven and the position as confirmed by the time the case reached the Court of Appeal is not relevant to the overall outcome. It's our contention that, in summary, first, as someone named as a dependent upon her mother's claim for asylum, P enjoys the same rights and protections as she would enjoy had she made a separate independent claim for asylum. Second, fundamentally for the purposes of this appeal, that includes a right not to be refooled. I say refooled, others say refouled. Refooled during the period whilst the initial claim for asylum is being considered and determined. Third, accordingly, an order for return made pursuant to the 1980 Hague Convention cannot, could not be enforced in relation to her. Fourth, in those circumstances, it was right and is right for a stay to be placed upon the Hague Convention proceedings pending determination of the asylum claim. And fifth, alternatively, if this court holds that the question of whether or not to stay 1980 Hague Convention proceedings in circumstances such as those which obtain in this case is one for a judge to make in the exercise of their discretion, we submit that the guidance which the Court of Appeal gave in relation to how that discretion should be exercised is wrongly suggests that it should be exercised with in favour of the final hearing of the Hague Convention proceedings continuing, notwithstanding that the relevant claim for asylum has not yet been determined. The appellant's appeal is divided, as my lords know, into three grounds which follow those contentions. The grounds of appeal appear at EF 23 to 31, and the issues are set out in the statement of facts and issues. My lords, I said I would deal in no great length at all, subject, of course, to my lords with the facts. The summary is in the statement of facts and issues, the chronology, EF 156 to 157, and also set out in the mother's statement filed at the outset of the 1980 Hague Convention proceedings, which is to be found at EF 147 to 154, Appendix Tab 13. In very, very short summary, the mother's a South African national, the father is Austrian. They met and commenced their relationship in South Africa. They were married in 2010. P, the child, who is confusingly referred to as G in some documents, but I'm going to use P, was born in May 2012. She is a joint South African and Austrian national. It's the mother's case that although in a relationship with the father and in due course married him, she's always been attracted to women. Her family, she says, is a very traditional African family, as she describes them, and she knew they'd disapprove of her sexuality. On her case, her family considers lesbianism to be unacceptable, homosexuality to be a sin, disgusting and wrong. The mother and the father's marriage broke down, and in 2014 they separated. He continued to reside with the mother. The father had regular contact. The mother asserts that the father used contact to perpetuate a control of her, and in due course she sought protection through the courts. In 2018, the parties divorced. The mother told her sister of her sexuality. That led to her sister leaving the mother's apartment and refusing to speak to her further. The mother then began to receive threatening telephone calls, telling her the way she was living was wrong and that she'd brought shame and a curse on her family. Examples in more detail are provided at EF page 162 and at EF page 393. At the end of May 2019, the mother's family invited her to the family home. There, she endured what she describes as a cleansing ceremony conducted by a sangoma. Details are in the mother's statement, EF 395 to 396, and in our written case at EF 162, paragraph 13. In short summary, the mother describes physical assaults, including cutting of intimate parts of her body with a razor. The intention of the ceremony was to correct the mother's lesbianism. She was told it would help her to become a woman and remove the curse so that she could attract a new husband and marry again. After that, the mother states she continued to receive threats. She reported them to the police, but was told that they were harmless and that they could do nothing. In February 2020, the mother was driving when another car, she says deliberately, pushed her off the road. The mother crashed. She believes that her mother did this. The mother's car was written off and sold for scrap. She used the money to buy tickets for herself and P to travel to England. On arrival, she claimed asylum with P as her dependent. The father commenced 1988 convention proceedings for the return of P to South Africa. That is a very limited summary of the factual background. I turn, if I may, to ground one. The first ground raises the following question: can a dependent child for an asylum claim have protection against refoulement whilst the claim for asylum is being considered by the Secretary of State? The appellant submits that the answer to that question is unequivocally yes. A child can, indeed, as a matter of international and domestic law, must have protection from refoulement where there are circumstances notified to the Secretary of State, indicating that the child may have an independent protection claim. This is also the answer provided by the UNHCR, which has supervisory responsibility in respect of the 1951 Refugee Convention. It was also the answer provided by the Secretary of State to the Court of Appeal and in her original written submissions to this court. We will structure our oral submissions on this ground in this way. First, a summary of the appellant's case. Second, the flaws as we say they are in the Court of Appeal's reasons. And third, a response to the key points made by the respondent in his written case. So first of all, the appellant's case. It's set out in detail in our written case. Obviously, in these oral submissions, I'm not going to cover that ground in the same way. The appellant's case rests on four propositions. When I say in the same way, in the same detail, I will outline those three propositions very briefly before I develop our submissions on each of them and then apply them to the appellant's case. First, refugee status is declaratory, not constitutive. Secondly, and related, the principle of non-refoulement applies to any refugee within a host state's jurisdiction, irrespective of whether the individual has had their refugee status declared. And third, it follows from the declaratory nature of refugee status and the fact that the non-refoulement obligation applies irrespective of determination of status, that a child may be protected by the non-refoulement obligation, irrespective of any recognition of refugee status, and indeed irrespective of any formal claim for refugee status. That obligation will apply where a child is named as a dependent in a parent's application, and the Secretary of State is on notice of evidence that the child may have an independent claim for international protection. In this scenario, a child cannot be returned until the Secretary of State has investigated and independently assessed whether the child is a refugee in his or her own right. So, my lords, proposition 1, refugee status is declaratory. We submit it's very well established that refugee status is declaratory and not constitutive. An individual does not become a refugee because he or she is formally recognized. My lord.
Amongst all the many submissions we've had in this case, I don't believe that this proposition is disputed.
Yes.
So at least for my part, you could take it as a starting point. The real issue is that although it's declaratory refugee status, nobody has a direct hotline, do they, to the truth? And so all the real question is about how you determine in practice when somebody is a refugee.
Yes.
It's the third stage of your argument that it's all about.
Yes.
You can't say that nobody who enters the country should ever be refooled just in case they might be a refugee without an investigation. So it's all about when you have to investigate the thing.
Yeah, it is, and we will undoubtedly come to that, my Lord. But we have it in mind, and I make it absolutely crystal clear now. It is not, of course, our case that the Secretary of State is hunting for needles in haystacks and has a responsibility somehow to survey the entire population of people coming into this country to see whether they may have a claim. It's a question of notice and machinery. And my Lord, I will continue, if I may, upon that basis, and won't dwell for too long on declaratory status, with that made clear. My Lords, the authorities for the proposition that we've just summarised are set out, and I don't go to them now, at paragraph 81 of our written case, EF 184, and we say that it is a principle that's been accepted repeatedly in the domestic courts, including this court, by the Court of Justice of the European Union and the European Court of Human Rights. References are, in our case, at EF 185, paragraphs 7 to 9 of the UNHCR's case, supplement EF 378 to 379, and indeed paragraph 15 of the Secretary of State's original written case, EF 6 to 7. And we believe that that paragraph, so with respect, my Lord Legate is right, survives the amendments made by the Secretary of State. The principle is also accepted by the respondent, who says at paragraph 51 of his written case, EF 227, there's no dispute that refugee status is declaratory, but, my Lords, he goes on to make what may appear to be a somewhat contradictory submission that, quote, it does not follow from that proposition that a person who may be a refugee cannot be required to leave the UK, close quote. And we will, of course, return to that. But for the moment, the key point is that it's common ground that refugee status is declaratory. No one seeks to challenge that. So I move on relatively swiftly to proposition 2, which relates to non-refoulement. This is addressed in paragraph 82 of our written case, EF 186, and with emphasis and authority, we suggest, by the UNHCR at paragraph 66, 6 to 22 of their written case, EF 378 to 383. And Article 33 of the Refugee Convention, set out at paragraph 46 of our written case, is a fundamental principle of international refugee law. It's reflected in Article 21 of the Qualification Direction, set out at paragraph 54 of our written case, EF 176. And the non-refoulement obligation applies to any refugee within a host state's jurisdiction, and it applies, we say, irrespective of whether or not that individual has had their refugee status declared. It's not linked to any domestic determination of status. The point's clearly made by Lord Dyson in ST Eritrea and the Secretary of State, 2012, 2 appeal cases 135. I don't need to take my Lords to it at this stage, but it's to be found at authorities 55, EF 2129, and at paragraph 61, Lord Dyson says, Article 33, that is the Refugee Convention, applies to refugees whether they're lawfully present in the territory or not. It applies to any refugee to whom the Convention applies. It provides the protection that lies at the heart of the Convention. If a refugee who is claiming asylum is to be protected from the risk of persecution, she needs the protection afforded by Article 33. End quote. At the domestic level, similar expressions of support are found in a number of other cases. We don't seek to turn them up at this stage, but if I can provide the court with the references to the judgment of Mr. Justice Green in Ibrahim and the Secretary of State, that's 2016 EWHC 2049, that's to be found at authorities 37 EF 1539, paragraph 44, and the judgment of Mr. Justice Holman in Ali and the Secretary of State 2012 EWHC 3638, which is authorities 28 EF 1331, and the reference within that is at paragraph 46. But as I said, I have no need to delay the court with taking my lords to those at this stage. At the European level, the Grand Chamber of the CJU, the Grand Chamber of the European Court of Human Rights in MSS and Belgium and Greece, 2011, 53 EHRR2, cited from the UNHCR's note on international protection, and the reference for the court, if it needs it, to the bundle, the authorities bundle is authorities 24 EF 1048, paragraph number is 56, and the relevant part of the note on international protection provided, as is summarized as follows, quote, a cardinal protection principle enshrined in the Convention, to which no reservations are permitted. In many ways, the principle is the logical complement to the right to seek asylum recognized in the Universal Declaration of Human Rights. It has come to be considered a rule of customary international law binding on all states. In addition, international human rights law has established non-refoulement as a fundamental component of the absolute prohibition of torture and cruel, inhuman, or degrading treatment or punishment. The duty not to reform is also recognized as applying to refugees, irrespective of their formal recognition, thus obviously including asylum seekers whose status has not yet been determined. It encompasses any measure attributable to a state which could have the effect of returning an asylum seeker or refugee to the frontiers of territories where his or her life or freedom would be threatened, or where he or she would risk persecution. This includes rejection at the frontier, interception, and indirect refoulement, whether of an individual seeking asylum or in situations of mass influx, end of quote. Finally, my lords, at the international level, there is the UNHCR's own note on the principle of non-refoulement, dating from November 1997. We provide it to authorities 70 EF 2645, and it explains as follows, quote, every refugee is initially also an asylum applicant. Therefore, to protect refugees, asylum applicants must be treated on the assumption that they may be refugees until their status is determined. Without such a rule, the principle of non-refoulement would not provide effective protection for refugees, because applicants might be rejected at the frontier or otherwise returned to persecution on the grounds that their claim has not been established. That the principle of non-refoulement applies to refugees irrespective of whether they've been formally recognised as such, that is, even before a decision can be made on an application for refugee status, has been specifically acknowledged by the UNHCR Executive Committee in its conclusion number 6 on non-refoulement. And further support can be found in the UNHCR's written case, paragraphs 6 to 22, EF 378 to 383, and indeed in the... Yes, my lord.
Again, Mr. Setrad, I don't think anybody is disputing that the principle of non-refoulement applies to asylum applicants. The question in this case is whether it applies to someone who's not made an application for asylum. That's what, as far as I'm concerned, we need to consider.
My lord, thank you very much. And fortuitously, perhaps, that is virtually the end of my proposition number 2. And so I'm going to advance to proposition 3, if I may. The third proposition relates to the practical application, and that is probably much more, therefore, a field of interest in this appeal of the 2 propositions that I put forward. The appellant's overarching submission, as I summarised to my Lord Legate a little earlier, is that the protection against non-refoulement will apply wherever the state is on notice that the individual may be a refugee. Uncontroversially in this appeal and in the decision of the Court of Appeal, partly the position of 1 or 2 of the non-public authority interveners before this court, this may arise because an individual has formally lodged a separate refugee claim, or it may apply where a child is listed as a dependent on a parent's asylum application, and there's evidence or information that is capable of proving that child meets the Article 1A2 definition of a refugee. And it's worth pointing out that in this particular case, in this particular application, there is such material in respect of the child P in the mother's application. More specifically, we submit there are 3 consequences that flow from the declaratory nature of refugee status, and the fact that the non-refoulement obligation applies irrespective of termination of status. They're set out in paragraph 84 of our written case. We say, first, if a child has formally lodged a separate independent application, the child cannot be returned while that application is pending, accepted by the respondent in the Court of Appeal, although it had been a matter that was potentially up for debate in the appeal. The respondent accepted it. The reference is EF 288, paragraph 135 in the Court of Appeal. No attempt by the respondent to cross-appeal the Court of Appeal's conclusion before my lords, so no appeal against that finding. We say the same must necessarily apply where the Secretary of State is put on notice of evidence that a child may have a claim for international protection. For instance, by way of a parent's application for refugee status or other international protection. And in this scenario, the child cannot be returned until the Secretary of State has independently assessed whether the child is a refugee in his or her own right or entitled to some other form of international protection. And third, if a child is granted a derivative form of status, such as being a dependent of a refugee or a dependent of a person granted humanitarian protection, the child should not be returned to the country of origin without first being afforded a reasonable opportunity to make a claim for refugee status in her or his own right, and the Secretary of State then having an opportunity to consider whether the child is a refugee in his or her own right or is entitled to some other form of international protection. The fact that a child has, because of the domestic asylum processes that are in place, been given a particular label does not mean that the child is not a refugee if they would otherwise satisfy the definition under Article 1 of the Refugee Convention. And we say that a return in those scenarios without independent consideration of whether or not the child is a refugee would give rise to a genuine practical risk of refoulement, and a risk of a return to serious persecutory harm contrary to this country's obligations under international and domestic law. And we say it's not a hypothetical risk. There are many scenarios underlying this appeal and the issues which are enshrined within it, where a child may have, for example, a stronger independent claim for international protection than does a parent, or a case that is different. A child may, for instance, face a risk of a child-specific form of persecutory harm, such as pre-puberty female genital cutting, deprivation of an education, parental abuse, involuntary gang or military recruitment, child marriage, or discrimination on account of being born outside of wedlock, to give a few examples. A child may also apprehend a level of physical, psychological harm, which in the case of an adult would not reach the requisite threshold, my lord.
In these situations, Mr. Setright, where the child has a potential claim for asylum, why is it not reasonable to expect that a parent who has abducted the child and made a claim on her own behalf will also make one on behalf of the child?
If my lord allows, there is a section of these submissions in which that is specifically grappled with. Would your lordship allow me to take that in turn?
Of course.
Thank you, but definitely we are coming to that. Where, for instance, notwithstanding the absence of a freestanding application by or on behalf of the child, a parent provides information in their own application capable of showing that his or her child could face serious harm if returned to her country of origin, the Secretary of State will be on notice that the child may have an independent claim, and we say must investigate and assess that claim before there is a return of that child. And we provide an illustration in greater depth based on...
I'm sorry, Mr. Setright,
yes,
I'm terribly sorry for interrupting. But I perceive that one of the precautions put in place by the Court of Appeal was to ensure that the child had separate legal representation, that is, independent legal representation. So I'm interested as to whether that legal representative, and the Court of Appeal said that that legal representative would have the benefit of access to the immigration documentation. So I was interested in whether that legal representative would have the ability to either make a claim on behalf of a child or withdraw a claim in circumstances where the claim was a sham claim. So that irrespective of the wishes and feelings of the child, acting in the child's best interests.
My lord, of course, that was a provision that the Court of Appeal made with support from us in the submissions that were made, I should say, in the Hague Convention proceedings. My lord, may I come to that, because it is a very interesting point, when I come to the second and third grounds which deal with much more centrally the Hague Convention proceedings. But my lord raises a question of, with great respect, very considerable interest with relation to the interplay between representation in the Hague case and activity out with it. One of the suggestions that we made in the application for leave by my learned friend to the Court of Appeal when making written responses was that the Court of Appeal might wish to hear from the child. And Kafka, but that was not taken further by anybody. And in the proceedings in the High Court and Family Division, there has been a degree of engagement by Kafkas, but as yet, we don't know whether any consideration has been given by Kafkas to that which my lord describes. Can it be done? Well, if I may, I'll come to that. But if my lord forgives, not in detail at this stage.
Well, when you do come to it, could you also formulate your position about whether the Secretary of State can be joined to the Hague Convention proceedings, so that the Secretary of State is fully aware of what is going on in those proceedings?
Yes.
And can coordinate the two aspects of these important conventions?
Yes. Again, and at the risk of throwing myself off course and taking up time, the point raised by my lord is one of great interest. And in another appeal to the Court of Appeal, which resulted in a remitted hearing before Mr. Justice Hayden, the thought was expressed that, for example, a judge sitting as a judge of the Family Division and of the Administrative Court might have some combined role, and investigations might take place. Those matters were not taken further. They may not arise directly out of this appeal, and certainly they're not in the mainstream of the submissions that I'm making, but I will be delighted to try to assist in any way that I can, and to formulate a position. But again, if my lord will forgive, not at this stage.
And was that a suggestion which Mr. Payne might like to consider? And that is that whichever body makes this decision, it should be the same body. That is, one's got Hague Convention proceedings ongoing. And certainly the tribunal appeals from any decision of the Secretary of State. I see absolutely no reason why that couldn't be conducted by the judge who has control of the Hague Convention proceedings. Have a little bit more difficulty about root and branch reform of who makes the initial decision. But certainly this divergence of the decision making is what causes problems in circumstances where, unfortunately, we don't even know what steps have been taken in the asylum claim.
My lord, yes. We have the system that we have, which provides, in contradistinction to some other international practice, as my lord see, particularly from the interveners, a system whereby the Secretary of State makes determinations. But my lord, if I may, I will come to those in due course. We will formulate a position which will be really a matter of opinion designed to assist the court in debating possibilities. But for the moment, if I may, I'll address the grounds in the appeal and come back to it.
The fundamental point is, how do you protect a child from spurious and sham asylum claims?
Well, that
by an abducting parent to improve their position at the expense of the child.
I understand what my lord means, I think, when he says that's the main point. We do say, of course, that in this particular case, that is not any such case. Because I have a real live client and a practical background to this case, I think I must say that.
No, I accept that, but I want the point of principle addressed. That is, how do we prevent, not your case, but other cases, where this is being used to abuse Hague return.
We will come to that.
Thank you.
So if I come back, I was going to illustrate to the court, and will if I may, an example of how matters practically arise. If we take an example of a child who may be at risk of a child-specific form of persecutory harm, such as female genital mutilation, her parent, whose application for asylum lists the child as a dependent, and has applied on the basis that she fears persecution on the basis of her parental opposition to female genital mutilation. The daughter, who's in fact at risk, does not lodge a separate claim. On the respondent's reasoning, and on the revised but not the original position of the Secretary of State, that child will have no protection against non-refoulement and could be returned. That is notwithstanding the fact that she's almost certainly a refugee, notwithstanding the fact that the Secretary of State would be on notice of that fact on the basis of the evidence provided with the parent's application. It serves, we say, to underline the surprising practical effects of the Secretary of State's open parenthesis, practice, close parenthesis, which was brought to the party's attention for the first time on Saturday. And according to the Secretary of State's note at paragraph 6, a caseworker, in this example, would consider the parent's application, recognise the child's independent need for protection, but would not then go on to determine the child's claim. Instead, the caseworker would invite the parent to make a formal application on behalf of the child. So a further mechanical process is introduced and a further hoop is devised to go through. Plainly, the Secretary of State is on notice that the child has a claim to refugee status, and yet that status will not be granted unless or until a formal application is made on the child's behalf. And we observe it may be that some parents would not make that application. What then? The appellant's position is entirely consistent with the domestic procedures and policy adopted in the United Kingdom and with the position the Secretary of State adopted in the Court of Appeal. In the United Kingdom, as we believe my learned friend Mr. Payne can confirm, it is standard practice for a parent to be listed as the principal applicant and for the spouse and children to be listed as dependents on the parent's asylum claim, given that if the principal applicant is granted refugee status or humanitarian protection, they will all be afforded a derivative status, which is largely equivalent to refugee status. In order to ensure the Secretary of State gives appropriate independent consideration for any dependents, she's developed the policy set out in the document which is named Asylum Policy Instruction, Dependents and Former Dependents, which is in its second version, last published in May 2014. And, my lords, it's worth looking at. It's the first document in the papers that I've taken my lords to. Can I take my lords to tab 61 of the authorities bundle, EF 2237, which is where the document starts. And my lords, if I go to EF 2240 within that document, the purpose of the instructions explained at paragraph 1.1. This guidance explains how caseworkers should process and consider asylum claims where a principal applicant has one or more family members who are either dependent on the claim or claiming asylum separately in their own right, or both. Therefore, the guidance expressly acknowledges the possibility that a dependent may have a claim in their own right. And if I go on with your lordships on the same page, paragraph 1.2, asylum claims may include one or more family members who are accepted as dependent on the principal applicant's claim. It's important to fully consider all the evidence available, including that provided by dependents or other family members who've made claims in their own right, and to recognise protection issues which may arise in the family context when considering such claims. So the Secretary of State must recognise, through considering all the available evidence, issues that arise in the family context. Those issues will include, surely, the possibility that a dependent, and particularly a child on whose behalf others must navigate the asylum application process, has a claim in her or his own right. And the legal reason for the position in the instruction is set out expressly in the document. Can I take my lords to EF 2241 and paragraph 1.4. Section 55 of the Border Citizenship and Immigration Act requires the Home Office to carry out its existing functions in a way that takes into account the need to safeguard and promote the welfare of children in the UK. Where an asylum claim involves dependent children, caseworkers must consider protection needs and the best interests of each child as an individual and in the context of the family unit. In most cases, and we seek to emphasise this, in most cases, the principal applicant will normally be able to set out any protection needs on behalf of their children to avoid putting children through an interview process unnecessarily. However, it's important not to lose sight of the child as an individual, as well as part of the family, to be vigilant and responsive to their protection and welfare needs, and consider how this could impact on the needs of the family as a whole. And finally, within this document, if I can take my lords to EF 2248, the introduction to section 5, which reads, relevant issues affecting dependents, which may give rise to individual protection needs, can come to light at any point in the asylum process, but are most likely to be identified through evidence provided during a defendant adult's screening interview, written evidence submitted in a one-stop section 120 notice, or by the principal applicant. It may also be important to gather additional information on key aspects of the claim from dependents, where this is necessary to fully consider the claim. And again, we put emphasis on the words that follow. Caseworkers should be alert to expressions of a need for protection from dependents that suggest they may have a claim in their own right, independently of the principal applicant. Where evidence comes to light suggesting a dependent who has not claimed in their own right has individual and specific protection needs, it may be necessary to interview them if such issues cannot be properly considered without further specific evidence from that individual. And my lords, we say that that provides an indication in depth that the Secretary of State was operating, should have been operating, on a basis consistent with our case, and indeed with the Secretary of State's own case as put before this court on the 18th of January. My lords, there is no requirement in these provisions that the evidence which provides indications which arouse the vigilance of the Secretary of State as described be provided in a particular form, still less that there be a freestanding application. Indeed, quite the reverse. Only that it be brought to the attention of the Secretary of State. So, my lords, if I can then turn to paragraph 87 of our written case, which is yes, I'm so sorry. I'm being reminded by my juniors, and as my lords may see, socially distant, I'm in the same room as all of them. I'm reminded that I may have gone slightly beyond 12 o'clock. Would your lordships like me to break?
Yes, we'll take a very short 5-minute break at this point. Thank you very much, Mr. Setright. Mr. Setright.
So if I move on from there, and in this part of my submissions, I'm hopefully addressing one of the questions asked by my Lord Legate. We, at paragraph 87 of our written case, I don't need to take your lordships to it at this stage, include an extract from the Secretary of State's skeleton in the court below, consistent with our position and the obligations which we've summarised, that if a parent's claim is rejected, there's a duty on the Secretary of State to consider whether that child is entitled to international protection. And in the court below, the Secretary of State stated in terms that it would be unlawful under European Union and domestic law for her to do otherwise. I don't need to go to that because instead I can go to her written case lodged in this appeal, and of course that written case dealt with matters of policy but also with matters of law, which was maintained without equivocation until Friday of last week. What I would like to do, if I may, is to take the court to that document, and it's supplement EF5, and to paragraph 8 of that document.
What's the electronic reference, Mr. Setright?
EF5.
5, thank you.
Supplementary. It's supplementary EF5. And if I take your lordships to paragraph 8, and within that paragraph, I may have a moment to make sure I'm in the right place. Yes, on the issue of principle, the Secretary of State contends that it is unlawful. So not, I interpolate, conflict of policy. It is unlawful for an order of the summary return of a child under the Hague Convention to be implemented, whilst a claim for international protection in relation to which the child has been made a dependent is pending before the Secretary of State, alternatively, before the dependent child has been given a reasonable opportunity to claim asylum in their own right. Well, my lords, we say that that's, with respect, an absolutely correct statement of the law. It was correct on the 18th of January. It's still correct on the 25th of January, notwithstanding the document produced on Friday. That paragraph has now been rewritten to state that there is no bar to returning a child in that scenario. My lords, we don't understand what effective explanation there is for such a change, and no doubt we will hear from Mr. Payne in due course and what he says about that. But it is our case that it was correctly stated there. And then, my lords, on, if I may, to, in the same document, EF11, and to paragraph 39. And there the document deals with the subheading, the Secretary of State's procedure relating to dependents. And it says, the Secretary of State's policy and procedures governing the approach to processing and determining claims for asylum is set out in various guidance and asylum policy instructions. The objective underlining these procedures is to ensure that obligations under the Refugee Convention, the QD and the PD, are in practice met. Again, we say that's entirely correct. And then on, my lords, if your lordships please, over the pages to EF page 14, paragraphs 49 to 53. I don't want to read them out. That's a wearying thing for the court to listen to my voice, and there are a fair few paragraphs. It's best for me to invite the court, if my lords are prepared to, just to read through paragraphs 49 to 53. And my lords, those paragraphs have not been excised in the Secretary of State's amended document. We rely on them, and they reflect the first two propositions that we make submissions on. But then, my lords, if I can take the court on to paragraphs 55 to 57, and invite the court to read those paragraphs, 55 to 57. Now, my lords, those paragraphs have been completely excised from the document which the Secretary of State now seeks to rely upon, notwithstanding the fact that plainly they were included on the 18th of January, plainly with the approval of both of my learned friends and with the approval of the Secretary of State herself, because no equivocation was provided or attached to the filing of that document. We say that those paragraphs are absolutely correct as a statement of principle and practice, and that they are correctly categorized as having been adopted in order to comply with the United Kingdom's obligations under the Qualification Directive, Procedures Directive, and the Refugee Convention. We say that they are what is required, not only as a matter of policy, but as a matter of law. And my lords, going on in this document to paragraphs 59 to 60, they provide some context. And my lords, if I invite the court to look at, in particular, paragraph 59, under the Secretary of State's procedures, it's a matter for the principal applicant, proposed adult dependent, whether the latter should make a claim for international protection in their own right or as part of the claim made by the applicant. Here we are moving clearly towards an exposition of a, quote, standard procedure, unquote. Whilst an adult dependent has to consent to be made a dependent, no consent's required from the child. As such, in the case of a child, it is the parent applicant who determines on behalf of the child whether the child exercises their right to make a claim for asylum in their own right, or whether they're simply named as a dependent. And then we place emphasis on the words that follow. In deciding whether to make a child dependent to their application, the parent applicant, by virtue of paragraph 329 of the immigration rules, would have no reason to consider that, in doing so, they were depriving their child from protection from refoulement whilst the claim was being considered, nor would any caseworker of the Secretary of State. So that is the statement from the Secretary of State as of the 18th of January. That is a statement correct and operative, we say, at all material times in the case which your lordships are hearing. That was the position that the mother of P was in when she made her asylum application and when she chose to make P a dependent, and she would have had every reason to believe that she had no reason to consider that by taking that course, she was depriving P of protection from refoulement. Plainly, the Secretary of State now seeks to depart from that. Again, we will wait with interest to hear what Mr. Payne says about it, but we say that that position, as set out in the document to which I've just referred, was correct. And if it's correct, as the Secretary of State says, no parent could conceivably think that in doing what this parent did, they'd be depriving their child from protection. That paragraph has been deleted in its entirety, and the Secretary of State's current position appears to be that that is precisely what a caseworker would think, that a child named as a dependent, potentially with evidence that that child has an even stronger claim than the parent, nevertheless, absent another step being taken. My lord.
Yes, sorry, Mrs. Seatright. And perhaps it's flagging up an issue for Mr. Payne later. But section 55 contains in subsection 1 an obligation in relation to the best interest of the child. But there's also a duty in section 55 subsection 3 to have regard to the procedures, the practices set out by the Secretary of State. I don't have to hand the exact wordings. I have difficulty at the moment in seeing how you have regard to something which is frustrated by removing the child from the jurisdiction. If you've taken us to the asylum guidance, which includes interviewing the child, and I'm not quite sure how you can interview the child if the child is no longer here.
Yes, Lord. May I come back to that with a specific reference? But with respect, yes, my lord. With respect, that's absolutely right. And we say it's another aspect of an internal inconsistency in the current position of the Secretary of State. I'm not going to preempt my learned friend, and will reply in due course. My Lords, that if we step back from the position on the Secretary of State's case as it now stands, after that shift in her position, what it also reflects, because by taking this step, the Secretary of State, who'd opposed the conclusions of the Court of Appeal, both before the Court of Appeal and in this appeal, what that position reflects is a real and far-reaching consequence of the Court of Appeal's decision. If it was to stand, its effect would be to remove this fundamental protection from children listed as dependents. And it's given rise to a situation where the Secretary of State may now appear to consider that it would be neither unlawful nor contrary to policy to remove, for instance, on our example, a child on which there is evidence of a risk of female genital mutilation, but exclusively on the basis that that child has not advanced a formal claim for refugee status, but has instead advanced it through the parent, because the Secretary of State will consider that, notwithstanding what I might term actual notice by the evidence before her, she does not consider that she does have notice or have sufficient notice. Finally, my Lords, in the Secretary of State's now in her case redundant document, but relied on by us, EF 22, paragraph 79, where it is set out that the appellant's suggestion that where through an application for international protection the Secretary of State is on notice that a dependent child may have their own claim, the dependent child cannot be required to leave the United Kingdom until the Secretary of State has determined the application, is consistent with the Secretary of State's position. Well, plainly no longer, my Lords, because that's been deleted without explanation. We say, putting it bluntly and succinctly, right first time, subject to what Mr. Payne may say, not right now. My Lords, to summarise and to return to our opening section, protection against non-refoulement will apply whenever the state's on notice that an individual may be a refugee. That may arise because an individual has formally lodged a separate claim, or it may arise where a child is listed as a dependent on the application and there is evidence or information, as in the present case, which is capable of proving that the child meets the 1A2 definition of a refugee. And just coming to the detail of that so that the court has the reference, in her asylum application, the appellant properly raised issues relating to the physical threat to P, the child, in South Africa, set out in our written case, EF 164 at paragraph 18. And as the Secretary of State submitted, the appellant or her legal representatives couldn't conceivably have thought that by doing what she did, she was depriving P in those circumstances of protection against non-refoulement. She couldn't remotely have forecast the changed position of the Secretary of State. Yes, my Lord.
Just going back to the Secretary of State's previous case, paragraphs 79 and 80, what's your position in relation to what's set out in paragraph 80 as the Secretary of State's position? Do you agree or not?
May I have a moment?
We can come back to
So
it.
sorry, Lord. We agree.
You agree? Okay, thank you.
And I think I gave the explanation a little earlier. I'm sorry for taking a little time to check with my learned friends. My lords, it follows, we say, that having expressed this concern for P's safety in her asylum application, there has been information and notice to the Secretary of State that P could be a refugee in her own right. It's not a needle in a haystack case. Here it is. And it's irrelevant in terms of this country's international obligations and the Secretary of State's obligations in particular, and in respect of the law, that the Secretary of State has been furnished with this evidence in this way rather than by way of a separate application. My lords, as a result, we say that non-refoulement protection must apply to prevent P being returned to South Africa prior to the determination of the asylum application made as it stands. Now, my lords, evidently, making a separate asylum application on the child's behalf would be another way of providing the Secretary of State with the same indication or notice. But there's currently no requirement in law, unless Mr. Payne says otherwise, that this is the only way to provide the Secretary of State with the necessary trigger for the application of the non-refoulement protection. To insist on such a requirement, if that is now the Secretary of State's case, elevates, we say, form over substance in a way that, with great respect, is self-evident. It's at odds with the requirement that asylum application procedures be fair and accessible, which includes being non-discriminatory on grounds of age. Accompanied child refugees are recognized as being particularly vulnerable because by virtue of accompanying another family member and a lack of legal capacity, they are rendered invisible as refugee applicants in their own right. And the UNHCR rightly emphasizes this, referring to the, quote, invisibly claiming child at paragraph 4, subparagraph 3 of their written submissions. So, my lords, having spent rather a lot of time on that point, and I pray forgiveness if it's been wearying, may I turn to the flaws as we see them in the Court of Appeal's reasoning. In addressing the interrelationship between an asylum application and an application under the 1980 Hague Convention, the court considered 4 different categories of children in respect of whom a left-behind parent may make an application for a return order. First category is a child who's had his or her refugee status recognized by the Secretary of State, and that's paragraphs 118 to 127 of the judgment, EF 284 to 286. I don't take my lords to them now. The second category is a child who's made an independent application for asylum and determination of that application is pending. And the reference in the Court of Appeal's judgment is paragraphs 128 to 131. The third category, a child who has made an independent application for asylum which has been refused but has appealed, and the determination of the appeal is pending. That's dealt with in the judgment of the Court of Appeal 132 to 136. And then category 4 of more immediate interest, a child who's not made an independent application for asylum, but who's been named as a dependent by a principal asylum applicant, and that is in the judgment at 137 to 140. And the Court of Appeal's reasoning in relation to each category is set out in our case at paragraphs 28 to 31 in summary. And we say that in respect of category 1, the court accepted that where a child has had his or her refugee status recognised by the Secretary of State, there is a bar to returns. Second, where there's a separate independent application for asylum pending, there's a bar to returns. Third, where a child's separate independent application has been refused, but an appeal is pending, the issue which plainly doesn't arise in the instant case was not determined by the Court of Appeal. All parties, of course, will have submissions on that third proposition. In respect of category 4, and therefore the subject matter of the appeal, the court held that there was no bar to return in those circumstances. And the critical elements of the reasoning set out in the judgment of 137 to 140 are these: that neither the Refugee Convention nor the Qualification Directive or Procedures Directive require, quote, any, close quote, and that's from paragraph 138 of the judgment, protection against the removal of a child that has not made any independent claim for international protection, which protection can only arise from the parent's application or considerations of family unity. And second, paragraph 139, the court acknowledged that the Secretary of State does in fact consider whether a court requires international protection where they are listed as a dependent, but considered that this is not properly construed as, quote, a form of deemed application for protection by the child. And finally, at 140 in the judgment, that paragraph 329 of the immigration rules, which prohibits the removal of dependents during the pendency of the principal applicant's asylum claim, quote, has nothing to do with the status and or rights of a refugee, close quote. It considered that it is, quote, not an emanation of the duty not to refool a refugee, but rather of the duty to have proper respect of family life, close quote. And we submit that the Court of Appeal made 5 main errors in its reasoning. First, the court adopted a flawed understanding of the declaratory nature of refugee status and the application of the non-refoulement obligation. And if I can, my lords, take the court to EF 268, which is the judgment, under paragraph 57 of the judgment. And here the Court of Appeal acknowledged that the rights protected under the Refugee Convention, quote, apply to a person from when and for so long as he or she satisfies the Article 1A criteria for a refugee, whether or not refugee status has been recognised. However, the Court of Appeal then went on in the following paragraphs to find that the position had been changed by the Qualification Directive and Procedures Directive. And in paragraph 61, the court said that those directives, quote, link refugee rights to the state's recognition of status in a way that the 1951 Geneva Convention generally does not, that view leads the court to conclude at paragraphs 119 and 125 that as a result of the EU directives, quote, a refugee's rights, including the right not to be recalled, are dependent upon and flow from formal recognition of that status, close quote. Now, the appellant submits that that is wrong in law. Recital 14 of the Qualification Directive, which is to be found at Authority 6 EF 561, expressly acknowledges that, quote, the recognition of refugee status is a declaratory act, close quote. This is the common ground which underlies so much of this case. Therefore, rights accorded to a refugee do not depend upon any formal recognition of refugee status. It's contrary to the Court of Appeal's suggestion. At paragraph 60 of the judgment, the Court of Appeal suggests that the general exhortation to respect the principle of refoulement in Article 21 of the Qualification Directive is restricted by Article 8 in the Procedures Directive. Article 7 applies to any person who has a pending asylum application. Quote, applicants shall be allowed to remain in the member state, close quote. Article 7 simply affirms the principle that the grant of refugee status is declaratory only, and therefore a procedure needs to be in place, again with respect to common ground, to ensure that no person who does in fact satisfy the criteria for refugee status is inadvertently before they've had the opportunity for that status to be recognised. In any event, we say there's no legal basis on which it would be impermissible for the Qualification Directive or Procedures Directive to alter the fundamental principles, of which non-refoulement is one, provided for under the Refugee Convention. And, my lords, we submit that Article 78 of the TFEU provides that the Qualification Directive and Procedures Directive must be in accordance with the Refugee Convention. The reference in the bundle is EF 588, and the Refugee Convention is itself the cornerstone of the European asylum system. The Qualification Directive and Procedures Directive are grounded in and afford primacy to it. So we say the Court of Appeal was wrong in saying that protection from refoulement is limited in the way that I have referred to. The respondent's objection, and I had said we would come to the respondent's case, this error in the Court of Appeal's reasoning relates to Category 1 cases of the 4 categories that I described, and thus did not form part of the Court of Appeal's reasoning in respect of Category 4 cases, that is, where a dependency claim is pending, does, with great respect, we say, miss the point. By conceptualizing refugee rights, including protection from non-refoulement, as deriving from the state's formal recognition of refugee status, the Court of Appeal was able to reach the conclusion that it did, in its own terms, in respect of Category 4 cases. That is because the child had not made a separate application. Article 7 of the Procedures Directive, and therefore protection from refoulement, did not apply. This deprives the principle that refugee status is declaratory rather than constitutive of any effect, with the attendant result that it limits the scope of protection from refoulement. Second, my lords, when looking at the errors which we say the court fell into, it adopted an overly formalistic approach to what it identified as Category 4 cases. And we say that the Secretary of State has in turn done exactly the same on Friday of this week. It mistakenly proceeded on the basis that if a child is named as a dependent in an application for asylum, that child cannot be a refugee. Of course, we say the reverse applies. First, the Court of Appeal's formalism is evident in its identification as Category 4 cases with the title, quote, child with no asylum application, close quote. It shows, we suggest, the telescope view taken by the court, not even contemplating the possibility that when a child is named as a dependent on a family member's application, that application may still indicate the child has an independent protection claim, which the Secretary of State is under a duty to consider separately of the principal applicant. In adopting that approach, the Court of Appeal ignored the reality of the standard practice, which I've referred to in some detail, whereby it's accepted that a dependency claim can be made without disadvantage in terms of protection against refoulement of the child, and that is a position in which claiming parents should have confidence, or at least that was the position. And that there was, in those circumstances, the court may construe little or any obvious benefit to lodging a separate claim. This is, of course, precisely why the Secretary of State adopted the approach set out in its asylum policy instruction, and the passages which I've already taken the court to. Caseworkers will be and must be alert to the protection needs when there isn't an independent claim made. In failing to recognise, my lords, even the possibility that a child named as a dependent on a parent's asylum application might raise an independent claim, the Court of Appeal's decision renders a whole category of children legally invisible, to use the UN phrase, to the Secretary of State, and imposes the formal and, we say, unnecessary requirement for those children to make an independent claim in order to have their refugee status recognised. The result of this invisibility is a real risk that a child named as a dependent on a parent's asylum application will actually be refooled, contrary to the Refugee Convention and the UK's human rights obligations. On the Court of Appeal's reasoning, which, as of Friday, has been embraced by the Secretary of State, a child has no protection against non-refoulement and could be returned, including in cases where realistically that child on any examination is almost certainly a refugee, and notwithstanding the fact that the Secretary of State has been placed on notice of that fact in the parent's application. We say, with great respect, that cannot be right as a matter of legal principle, my lord, or practice. Yes, Rob.
Yes. Can I just at this point ask you a matter that's been troubling me, but it's your test of the Secretary of State being on notice that the child may be a refugee. I just wonder exactly how that pans out. So let's assume we've got a mother's application which doesn't explicitly refer to the child's own position, but you might say, well, digging around beneath the surface, you might say that the child could have a refugee status. Is that sufficient? So that's one example on your test. Another example might be where the mother has made it absolutely explicit, but it doesn't strike, or it might not strike a reasonable person as credible that explicit reference is actually correct. So in other words, what I'm pressing on is this test of on notice, how does it pan out?
because I'm just concerned about your points about form and substance. And this could be taken back to a different level about form and substance. So how does the test pan out? Sorry, it's a rather long question.
But my lord, with great respect, a good one. May I formulate and deal with, when I've reached the end of round one, what we say about that. But we say that in any event, my lord, the Secretary of State's solution, and arguably the Court of Appeal's solution, which is, well, there's an easy binary answer to this. It doesn't matter how strong or weak the evidence is, it's not valid. But by the same token, it doesn't matter how strong or weak the evidence is. If the child makes a freestanding claim, it will be considered and the bar will operate. Well, none of that addresses the points which, the qualitative points, if I can call them that, which my Lord Burrows makes. So can I come back to that? My lords, looking at our points against the Court of Appeal, as it were, the third point, we say, is that the Court of Appeal's approach seems to have been driven by what we would describe as an overly expansive interpretation of the decision in the case of JS Uganda and the Secretary of State 2019, which is to be found, and I don't think I need at this stage to take your lordships to it, in Authorities 38 EF 1619. In that case, the Court of Appeal considered the Refugee Convention and protection from refoulement afforded to an individual who had been made the subject of a deportation order as a foreign criminal, but who had previously been granted leave as a dependent of a family member. The court held that the protection he had been granted was derived from the protection granted to the family member, and that that did not mean that the individual was a refugee for the purposes of the Refugee Convention, and that proposition is to be found at paragraph 150 of the judgment. Well, that's plainly right, and my lords, the appellant doesn't seek to challenge that in this appeal, but where the Court of Appeal, we say, was led into error, was in supposing that the effect of that decision in JS Uganda is that an individual that is either listed as a dependent or granted a derivative form of status is always incapable of being also a refugee for the purposes of the Refugee Convention. And Lord Justice Underhill appreciated the very point, and I can give the court a precise reference. It's at paragraph 190 of the judgment, which is EF 1633, and I needn't, unless the court wishes, take the court to it, but I'll just read the short paragraph in full, or read the short paragraph. I should like to observe, at the risk of spelling out the obvious, that this issue only arises in cases where the risk of persecution which leads to the grant of protection to the, quote, primary, close quote, refugee does not also extend to his or her family members. Very often, of course, it will, either because they share the same characteristic as gives rise to the risk, or because the persecutor will extend his persecution of, say, a political activist to his or her family members, irrespective of their own conduct or opinions. So the Court of Appeal fell into error there in a way that we say is, with great respect to them, obvious. Fourth, the Court of Appeal mistakenly minimised the legal importance of the approach the Secretary of State adopts in her asylum policy instruction. But paragraphs 87 to 88 of the judgment, and that's page 276 of the electronic bundle, the Court of Appeal acknowledged the procedural approach that the Secretary of State adopts where children are named as dependents, but concluded that the asylum policy instruction was mere policy and didn't reflect a legal obligation. And my Lord, I'd invite the court to save time in listening to me to read paragraphs 87 to 88 of the judgment to see what the Court of Appeal said. In other words, this reasoning, we say, fails to appreciate that the Secretary of State has adopted the procedural approach that she has in order to avoid the risk of inadvertently returning a child to a risk of persecutory harm in breach of the United Kingdom's non-refoulement obligation. If the child is a refugee or otherwise entitled to protection against refoulement, it's irrelevant whether the child has made a form of deemed application. The respondent's only response to this point is to emphasize that the asylum policy instruction lacks, quote, the force of law, close quote, which is paragraph 74 of Maloney's friend Mr. Deverex's written case. The appellant doesn't contend otherwise. Rather, it submitted that the legal principles on which we've made these submissions underpin and mandate the Secretary of State's approach in the asylum policy instruction. And the respondent submissions, of course, subject to anything Mr. Deverex may say orally, has thus far failed to engage with that at all. Finally, in respect of our headline reasons against the Court of Appeal's judgment, the Court of Appeal gave insufficient regard to Section 55 of the Borders, Citizenship and Immigration Act 2009. That's found at tab 9 of the authorities bundle. It's EF 595. I don't need to take the court to it at this moment, but it requires, and this is a point which my Lord Burrows alluded to, it requires the Secretary of State to have regard to the need to, quote, safeguard and promote the welfare, close quote, of children in making decisions affecting immigration and asylum status. And plainly that is engaged. If the court turns in this context to paragraph 89 of the Court of Appeal's judgment, electronic bundle 276, there the court acknowledged, pause for a moment, there the court acknowledged that, quote, even where the principal application is refused, the Secretary of State will consider the child in the context of Section 55 of the 2009 Act, which may lead to a grant of leave to enter or remain. And, then going on to the next relevant words, again, that policy which is entirely distinct from the policies which seek to protect dependents who have an independent claim for international protection is understandable and probably an inevitable consequence of Section 55, close quote. The court, with respect, was mistaken in characterizing this as a policy. Section 55 imposes a legal duty on the Secretary of State, set out in a piece of primary legislation, to have regard to the best interests of the child when taking any immigration decision. It applies irrespective of whether the child is listed as the primary applicant or a dependent. And Section 55 explains why the Secretary of State has adopted the process she has, and explains why the Secretary of State is alive to the need to look for evidence of an independent claim, at least, my lords, on the basis of a case up to Friday. And to make that good, in EF 14, in the Secretary of State's case, paragraph 48 makes that out clearly. My lords, I got a few minutes left this morning. I will seek to make headway in my analysis of the respondent's case and stop at hopefully on 1 o'clock and continue briefly on round 1 after luncheon. On the respondent's written case, the sole argument of legal principle is that non-refoulement doesn't apply to a person who may be a refugee. We say that's a remarkable proposition in the light of everything that we have outlined, but it's made at paragraphs 45 to 47 of Malone Trend's written case, EF 225 to 227. And we say that that is wrong and without merit, with great respect. My lords, I think it is now precisely 1 o'clock. Would your lordships like me to stop at that point and to resume at 2?
Well, if it's a convenient point, Mr. Satterite, we'll stop there and we'll resume at 2 o'clock. And I think under the timetable, you're going to go on until 3:15, I believe.
I am.
Very good. Thank you very much. 2 o'clock. Thank you very much.